Picture this. You've got a courtroom, really high stakes. There are these confidential government documents, and it's basically a battle over legal secrets.
Yeah, it sets the scene perfectly. An individual wants information, desperately needs it, maybe.
Right, and the government is standing there saying, nope, sorry, privilege.
Exactly. And that core conflict is right at the heart of the case we're diving into today. Mann v. Carnell. It all played out in the ACT.
A real courtroom saga. Let's quickly introduce the key players, the main characters in this drama.
Okay, first up you have Dr. Arnold Mann.
Yeah.
He's the one seeking the information.
Then there's Kate Carnell, who was the chief minister of the ACT at the time. The government side, essentially.
And caught someone in the middle, Michael Moore. He was a legislator, MLA, whose inquiry kind of sparked the whole thing.
So our mission today for this deep dive is to really unpack this complex legal fight. We want to understand how it all unfolded, through the different courts.
And meet the people involved, see their motivations.
And ultimately reveal how this case fundamentally changed the rules around something called legal professional privilege right here in Australia.
Absolutely. And it's important to remember, this isn't just some dry legal argument. There's a very human story here woven into the workings of government and law. It's about someone fighting for what they believe is right.
Definitely. So let's get to know these individuals a bit better. Our dramatis personae, as you called them.
Right. Each one is critical to understanding why this case happened and why it matters.
Let's start with Dr. Mann, Dr. Arnold Mann. The sources paint him as a celebrated surgeon.
Yeah, top of his game professionally. But when this particular story kicks off, he's also described as being, frankly, furious.
Yeah.
Really frustrated about how a previous lawsuit ended.
The original lawsuit, the one before this privilege case started.
Exactly. He'd been in this long legal battle with the ACT health authorities, the Board of Health. Went on for 6 years.
Wow, 6 years.
Yeah, a long time. And it didn't end with a judge deciding who was right or wrong. It ended with a settlement.
Okay, a settlement. But he wasn't happy about it.
Not at all. The deal was $400,000 was paid into court for all the defendants. Dr. Mann accepted the money.
Sounds like a decent outcome.
Well, here's the kicker. The payment was made without any admission of liability. So the defendants didn't say they did anything wrong.
And for Dr. Mann, that was the problem.
Precisely.
Yeah.
He felt completely deprived of the chance to, clear his name, to vindicate his position publicly, especially if he felt his reputation had been attacked during that original fight.
So even with the $400,000, he saw it as unfinished business and a waste of money.
A monumental waste of public funds. Those were his exact words, quoted in the sources. He was really angry about it. He even accused the territory, basically the government behind the health board, of deceitful behavior.
So this wasn't just about him anymore. It was about public accountability, too.
That seems to be a big part of his motivation for what came next. He wanted to understand why the government settled like that. Was there wrongdoing? Was there information in the government's files that could clear his name, maybe even show he'd been defamed? It wasn't about getting more money from the old case.
And that led him to fight this new battle himself.
Yeah, which is incredible. The sources point out he acted as a self-represented litigant in person through most of this incredibly complicated legal journey, taking on government lawyers all the way to the high court. That shows some serious personal resolve.
Absolutely underscores the personal stake he had in this. Okay, next up, Kate Carnell, the chief minister.
Right. She's holding the reins of executive power in the ACT, and she's facing this classic political tightrope walk.
Balancing transparency with secrecy.
Pretty much. Transparency about how public money is spent, like that $400,000 settlement, versus the government's need to keep its internal legal advice confidential, so they can get frank advice without worrying it'll end up in the newspaper or in the hands of someone suing them.
And her decision on how to handle that balancing act is what lit the fuse for this case.
Exactly. Her action, sharing certain documents to try and navigate this political dilemma, is what sparked the whole legal firestorm over privilege. She was trying to manage a situation, respond to an inquiry, but it had these huge, unforeseen legal consequences.
Okay, and the third person, Michael Moore, the independent MLA.
Michael Moore. He's the legislator doing his job right, keeping an eye on the government for the public. He picked up on Dr. Mann's concerns about that settlement money.
The monumental waste of public funds?
Yep, he used the same phrase when he wrote to the Chief Minister. His inquiry is what put Carnell in that difficult position.
And him being an independent MLA was important?
Potentially very important. In smaller parliaments like the ACT's, Independents can often hold the balance of power. Keeping them happy, or at least satisfied with government explanations, can be politically crucial.
And the sources mention he later became a minister in her government.
They do. He became health minister under Carnell. Now, you can speculate whether the way she handled his inquiry, including sharing those documents confidentially, helped build the trust needed for that later political alliance. It's certainly an interesting footnote. He starts as the inquirer and ends up central to the legal dispute about the information he received.
So we have our players, the determined surgeon, the chief minister in a bind, the inquiring legislator. Let's walk through how this actually started. It all goes back to Dr. Mann's original lawsuit settlement, doesn't it?
It really does. That initial settlement is the seed for everything that follows. So remember, 6 years of litigation against the ACT Board of Health and others.
Ended in December 1995.
Right. With that $400,000 paid into court, no admission of liability.
Which Dr. Mann publicly slammed.
Yes, loudly and clearly. Monumental waste, deceitful behavior. He wasn't quiet about his frustration.
And that got Michael Moore's attention.
It did. As an MLA, he took up Dr. Mann's concerns. In January 1996, just a month after the settlement, he writes this letter to Chief Minister Carnell.
Using that same phrase.
Yep. Monumental waste of public funds. He asks her for an assurance that this kind of thing wouldn't happen again. And significantly, he copies Dr. Mann on the letter.
So Carnell knew that Mann knew his concerns were being raised at the top. Puts her on the spot.
Absolutely. She's got this letter from a key independent MLA echoing public criticism, and the critic himself knows about it. She needs to respond effectively.
What were your options?
Well, she needed to satisfy Moore, show the government wasn't wasteful, and ideally convince him the settlement was actually a smart move, maybe saving taxpayers even more money than going to trial would have cost.
And the best way to do that was?
To show him the reasoning behind the decision, to show him the internal advice.
The confidential legal advice.
Exactly. Carnell made the decision to provide Moore with copies of the key documents that explain the government's thinking.
What kind of documents are we talking about? Not just memos, presumably.
No, definitely not. We're talking serious legal work product. Specifically, the sources mention 3 separate legal opinions from senior counsel barristers hired to advise the territory during that long original lawsuit. Plus, a detailed report from the ACT Government Solicitor's office to the Department of Health.
And what was in those documents?
Highly sensitive stuff. The government solicitor's report apparently summarized the whole 6-year history of the case, talked about counsel's advice, the legal issues, the risks, the potential outcomes. The senior counsel's opinions, they would have contained really frank assessments of the territory's chances, the weaknesses in Dr. Mann's case, the strengths, strategic advice on whether to settle or fight. Everything you'd expect in confidential legal advice.
The kind of stuff you really don't want the other side, Dr. Mann, in this case to see.
Absolutely not. That's the whole point of privilege. But Carnell gave copies to Moore. Her explanation, according to the sources, was that she gave them for his information.
On what basis?
She believed she was communicating with another legislator who had a legitimate reason to know, related to government spending and accountability. And crucially, she believed that because she gave them to him confidentially, the legal privilege protecting them wouldn't be lost.
So the understanding was Moore wouldn't share them further.
That seems to have been the basis. She hoped this private briefing would satisfy Moore, show the settlement was prudent, and stop him from digging any further, maybe publicly.
A calculated risk, it seems.
It certainly turned out that way, because Dr. Mann knew Moore had received something, and he suspected those documents might contain stuff about him, maybe defamatory stuff.
Which leads us to the courtroom, the ACT Supreme Court.
Exactly. Dr. Mann couldn't just demand the documents from Moore or Carnell, so he used a specific legal tool.
He didn't just sue for defamation straight away?
No, because he hadn't seen the documents. He needed to know if he actually had a case, so he applied for something called preliminary discovery.
Preliminary discovery, trying to get documents before filing the main lawsuit.
That's the gist of it, yeah. Under the court rules at the time, Order 34A, Rule 5, I think you could do this if you reasonably believed you might have a right to sue someone.
Like for defamation.
Right, but you didn't have enough info to decide whether to actually launch the case. You also had to show the other person likely had relevant documents, and seeing them would help you make that decision.
And Mann argued the settlement documents held by Carnell fit that bill.
He did. He believed they might contain defamatory statements about him, which could give him grounds to sue Carnell or the territory. So he asked the court to order Carnell to produce those documents she'd given Moore.
Makes sense, but there was a problem.
A big one, built right into the rules for preliminary discovery. Order 34A, Rule 2. It explicitly said you couldn't get an order for documents if they were protected by privilege.
Ah, the shield of legal professional privilege, which Carnell thought she still had.
Exactly. So when Dr. Mann filed this application, the response from Carnell, represented by the ACT Government Solicitor's Office, was immediate. These documents are protected by client legal privilege.
That's the core legal principle protecting lawyer-client communications.
That's the one. Confidential communications made for the dominant purpose of getting or giving legal advice or for use in litigation. The government argued these documents were classic examples of privileged advice given to the territory. They also mentioned potentially claiming public interest immunity, but the main fight was definitely on legal privilege.
Did they provide evidence to back up the privilege claim?
Yes, they filed an affidavit, a sworn statement from a solicitor in the ACT Government Solicitor's Office, a Mrs. Lisa Jane Manzoni. Her affidavit described the documents, confirmed they contained legal advice about Dr. Mann's earlier case, and asserted they were privileged.
So it boiled down to two questions for the judge, Chief Justice Miles.
Pretty much. First, were these documents privileged in the first place when they were created? And second, the million-dollar question. If they were privileged, did Carnell waive that privilege, lose it, by giving copies to Michael Moore?
And what did Chief Justice Miles decide?
He dropped a bit of a bombshell, ruling entirely in favor of Dr. Mann. He granted the application.
Yeah. So he found the privilege was lost. How?
His reasoning was interesting. He agreed with the government on point one.
Yeah.
Yes, the documents were definitely privileged when the lawyers originally gave the advice to the territory. That was a privileged occasion. But, he said, Carnell giving copies to Moore later on, that was a different occasion of publication. And he found that this second occasion, the sharing with Moore, was not protected by privilege.
So just the act of giving them to Moore, even confidentially, destroyed the privilege.
That was essentially his view. He saw Moore as the third party, a stranger to the original lawyer-client relationship. And by passing the documents to this stranger, even with an understanding of confidence, the fundamental confidentiality required for privilege was, in his view, lost. The secrecy was broken by that subsequent disclosure.
That seems quite a strict interpretation of waiver.
It was certainly a significant finding. And based on that privilege lost Miles, CJ ordered Carnell to produce the documents for Dr. Mann to inspect. A massive win for Mann at that stage, especially representing himself against the government's lawyers.
You mentioned earlier the law around this was a bit uncertain then.
Very much so. This was around the time the new Commonwealth Evidence Act 1995 had come in, including in the ACT. It had new rules for creating privilege, the dominant purpose test, and specific sections, like Section 122, dealing with how privilege could be lost.
But did that act apply to discovery before a trial?
That was the big debate. Did the Evidence Act rules replace the old common law rules for pre-trial stuff like discovery? Or did common law still govern discovery, maybe informed by the Act's principles? Different courts were saying different things. Cases like Adelaide Steamship v. Spalvins were exploring this. Chief Justice Miles's ruling, focusing on the occasion of publication and finding waiver pretty readily, added fuel to that fire.
Okay, so Mann wins round one in the Supreme Court. Documents ordered. The government must have been unhappy.
Unhappy is an understatement. Alarm bells ringing, definitely. The prospect of handing over confidential legal strategy documents to Dr. Mann was not appealing. They reacted immediately. Straight away. They appealed Miles CJ's decision. Because of the way the courts were structured then in the ACT, the appeal went to the full court of the Federal Court of Australia, sitting in Canberra.
And the case name changes now.
Yep, Carnell becomes the appellant, the one bringing the appeal. So it's Carnell v. Mann.
Who are the lawyers this time? Did the government bring in the big guns?
They did. The ACT Government Solicitor's Office was still handling the case. But for the federal court appeal, they briefed senior counsel, Mr. David Erskine, to argue Carnell's case.
And Dr. Mann, did he get lawyers for the appeal?
Remarkably, no. He continued to represent himself, stood up in the full federal court, 3 experienced judges, Justices Higgins, Lehane, and Weinberg, and argued his case in person.
That's extraordinary. The image of the self-represented surgeon against the government's senior barrister.
It really highlights the personal dimension of this fight for him. He was defending the win he'd secured.
So what happened in the federal court? Did they agree with Chief Justice Miles?
No, they didn't. The judgment was unanimous. They overturned Miles C.J.'s decision completely.
Unanimous again, but the other way. Why? What was their reasoning?
They fundamentally disagreed about waiver. They held that the privilege had not been lost when Carnell gave the documents to Moore. Their reasoning was based on common law principles of waiver, looking at fairness and inconsistency.
Okay, so common law. But did they consider that Evidence Act issue?
They did, and this is crucial. They took the view that while the Evidence Act might not directly apply to discovery, its principles, especially regarding waiver in Section 122, should inform how the common law was applied. This was a view gaining traction at the time, influenced by cases like Spelvin's.
So they used the act as a guide.
Essentially, yes. Applying that lens, they looked at the disclosure to Moore. They said it was done for a proper purpose, helping a legislator perform their oversight function regarding public money. They noted Moore had kept it confidential.
And therefore?
Therefore, they concluded, this limited confidential disclosure for a proper governmental purpose was not inconsistent with maintaining the overall confidentiality of the advice. It wasn't like publishing it to the world. It was a controlled sharing within the governmental sphere.
So unlike Miles C.J., they didn't see giving it to Moore, the MLA, as automatically breaking the privilege.
No, they saw it as compatible with maintaining privilege, given the context. Confidential sharing, proper purpose, legislative oversight.
So the federal court sided with the government. Carnell's appeal was allowed.
Correct. The order forcing her to produce the documents was set aside. Dr. Mann was back to square one, legally speaking. The door to those documents slammed shut again.
What a roller coaster. Win in the Supreme Court, lose in the federal court. Did Dr. Mann accept that?
Not a chance. His determination was unwavering. He decided to take the fight to the very highest court in the country, the High Court of Australia.
Getting a case heard in the High Court isn't easy, is it? You need special leave.
Exactly. You have to convince the High Court that your case involves a really important question of law, or is of significant public importance, or that it's necessary to resolve conflicting judgments in lower courts. The fact they granted Dr. Mann special leave to appeal shows just how significant the legal issues around privilege and waiver in this case were considered.
Who was on the High Court bench for this final showdown?
A very senior lineup. 6 justices heard the appeal. Chief Justice Gleeson and Justices Gaudron, McHugh, Gummo, Kirby, and Callanan. A full bench, essentially, ready to tackle these complex issues.
And Dr. Mann, surely he got legal representation for the High Court.
Incredibly, no. The sources confirm he argued his own case in person before the High Court of Australia, standing alone against the might of the government's legal team.
And who was arguing for Carnell and the ACT government?
The ACT Government Solicitor's office remained the instructing solicitors. While the specific senior counsel isn't named in the outline material we have, you can be absolutely certain they engaged top-tier appellate counsel for a high court fight like this. The arguments presented, though, reportedly followed the successful path laid out by Mr. Erskine in the federal court.
So what was Dr. Mann's main argument to the High Court justices? What was his plea?
His argument likely centered on fairness, transparency, and the idea that confidentiality had been broken. He probably hammered the point that Moore was a stranger to the executive's lawyer-client relationship.
Right.
And that giving these documents potentially containing defamatory material about him, paid for by public funds to this stranger, Mr. Moore, had to be a waiver of privilege. He'd argue it was fundamentally unfair to let the government selectively share this information with a politician while keeping it secret from him, the person directly affected. His core message would have been about accountability and his right to know if he'd been wronged.
And the government's counter-arguments. What did Carnell's lawyers say?
They would have built on their federal court win. First, reiterate that the documents were definitely privileged legal advice given to the territory.
Standard starting point.
Second, that Carnell, as chief minister, was acting properly within her role in handling this advice. Third, the key point. The disclosure to Moore was not a waiver. Why? Because it was confidential. It was to an MLA. And it was for a legitimate purpose, responding to that inquiry about public funds, facilitating responsible government.
They'd stress the need for government to function.
Absolutely. They'd argue that confidential briefings between the executive, like Carnell, and the legislature, like Moore, are essential. Ministers need to be able to explain sensitive matters to MLAs without fearing every briefing automatically destroys privilege.
What if they couldn't brief confidentially?
Then, the government might argue, legislators would resort to using parliamentary privilege to demand documents publicly. And that, as Justice Kirby later pointed out in his judgment, could be far more damaging, leading to broader disclosure with fewer protections for people named in the documents.
So the confidential briefing was the lesser evil, in a way.
That was likely part of the argument. Therefore, they concluded the confidential disclosure to Moore was not inconsistent with maintaining the privilege overall. It wasn't abandoning secrecy, it was a controlled internal communication.
And the High Court also had to finally sort out that big question. Evidence Act rules or common law rules for waiver in discovery?
Yes, that was hanging over everything. Which set of rules applied before trial? Lower courts were split, and conveniently, the High Court was looking at this exact issue in another massive privilege case at the same time, Esso Australia Resources Ltd v. Commissioner of Taxation. So Mann v. Carnell became a crucial vehicle for settling this fundamental point.
Okay, the arguments are made, the legal context is complex. What did the High Court decide? What was the final verdict?
The High Court delivered its judgment. By a majority 5 justices to 1, they dismissed Dr. Mann's appeal. The government won.
So the federal court decision stood. And how did the majority resolve the Evidence Act versus common law debate?
This was huge. They made it crystal clear. Consistent with another case, GPAO, and the Esso decision they handed down around the same time, the High Court majority ruled definitively. The Evidence Act 1995, including its rules on privilege and waiver, does not apply to pretrial processes like discovery.
Why not?
Because the Act's wording, they said, is all about adducing evidence, meaning presenting evidence at a trial or hearing. Discovery happens before the trial. Therefore, questions of privilege and waiver during discovery must be decided purely by the common law.
So the federal court's approach of using the Act to inform the common law was wrong.
Yes, the High Court majority rejected that approach. It was common law rules only for discovery.
Okay, so under the common law, what test did the majority apply for waiver?
They applied the established common law test, drawn from cases like Grant v. Downs and Attorney General and T. v. Maurice. The test is whether the conduct of the privilege holder, the client, is inconsistent with maintaining the confidentiality that the privilege is designed to protect.
Inconsistency, not just fairness.
Exactly. The majority clarified that while fairness might play a role in some specific waiver situations, like accidentally disclosing part of a document, the fundamental test is objective inconsistency. Is what the client did fundamentally incompatible with keeping the communication confidential from the person seeking access? It's not about the client's subjective intention.
And applying that inconsistency test to Carnell giving the documents to Moore.
The majority found no inconsistency. Their reasoning was that the disclosure was made confidentially to Moore, and it was for a proper governmental purpose responding to his legislative inquiry about public spending. They saw this as a normal, even necessary part of a responsible government minister's briefing MLAs confidentially.
So sharing it confidentially within that government sphere wasn't seen as inconsistent with keeping it confidential from Dr. Mann or the public.
Precisely. They reasoned that this limited confidential disclosure didn't undermine the core purpose of the privilege, which was to allow the territory to get confidential legal advice without fear of it being revealed to opponents like Dr. Mann. Carnell's actions weren't inconsistent with wanting to maintain that protection against him.
So the bottom line, privilege was not waived.
Correct. No waiver occurred through the confidential disclosure to Moore. Therefore, the majority dismissed Dr. Mann's appeal. The full federal court's decision was upheld. Carnell was protected by privilege, and under the discovery rules, 034AR2, she didn't have to produce the documents.
And the costs. Did Dr. Mann have to pay for the High Court appeal?
Yes, the standard order followed. Dr. Mann was ordered to pay Chief Minister Carnell's costs for the High Court proceedings. A tough outcome after such a long fight.
But it wasn't unanimous, you said. One judge disagreed.
That's right. Justice Michael McHugh wrote a powerful dissenting judgment. He saw the whole situation very differently.
Where did his reasoning differ so sharply from the other 5 justices?
His starting point was the constitutional structure of the ACT. He stressed the separation between the executive arm, Carnell and the government, and the legislative arm, Moore and the Assembly. While part of the same overall government, they were distinct.
More emphasis on separation of powers.
Exactly. And because of that separation, he argued, Mr. Moore, as an MLA, was effectively a stranger to the legal professional privilege held by the ACT executive over its legal advice. He specifically rejected comparing MLAs to shareholders who might have some right to company information.
So, if Moore was a stranger, what did that mean for waiver, in McHugh's view?
He proposed a much simpler, stricter rule. If the privilege holder, the executive, voluntarily discloses the privileged document to a stranger, Moore, then the privilege is lost, automatically. ipso facto by that fact alone. He argued the government should be treated just like anyone else. Share your secrets outside the circle, you lose protection.
He seemed quite concerned about the fairness aspect, too.
Very much so. He found it problematic that the executive could choose to share potentially damaging information with select legislators, perhaps for political reasons, while keeping it hidden from the person directly affected, like Dr. Mann, who suspected he was defamed. He felt that wasn't right.
So Justice McHugh would have let Dr. Mann see the documents?
Yes, he concluded that justice and common sense required allowing Dr. Mann access. He would have allowed the appeal and brought back Chief Justice Miles' original order for production. But of course, his was the dissenting view. The majority decision became the law.
So the High Court ruling finally settles the main legal battle over the documents. But you mentioned costs earlier. What happened with the costs from the original Supreme Court hearing?
Ah, yes, that was a loose end. The High Court ordered Mann to pay Carnell's costs for the High Court appeal. But the costs of that very first application, back before Chief Justice Miles, where Mann initially won, still needed sorting out. That came back to Miles CJ in March 2001.
And given Mann ultimately lost the war, did Miles CJ just order him to pay Carnell's costs for that first battle too? The usual loser pays rule?
Interestingly, no. He actually departed from the standard rule. Chief Justice Miles ordered that each side should bear their own costs for that initial Supreme Court application. No costs order either way.
Why did he do that? That seems unusual.
He gave specific reasons. He acknowledged that while Mann had his personal motivations, there was also a strong element of public interest in the case, raising important questions about government privilege and accountability. He also pointed out Mann hadn't completely succeeded or completely failed. He won round 1, lost rounds 2 and 3.
And a resource difference.
That was key. Miles CJ explicitly noted that Carnell's costs were covered by the public purse the territory was paying, whereas Dr. Mann was paying personally, and had already been hit with the High Court costs order against him. Citing principles from public interest litigation cases like Oshlak, he decided it would be unfair in these circumstances, given the public interest factor in the outcome, to make Mann pay the territory's costs for that first instance hearing where he'd actually won.
So a small concession at the end, acknowledging the nature of his fight.
You could see it that way, recognition that it wasn't just a purely private dispute.
What about the people involved? What happened to them after all this?
Well, Dr. Mann finished his legal battle and, as far as we know, returned to his surgical practice. His name, though, is now firmly in the law books. Kate Carnell remained chief minister for a while longer, but eventually resigned over a different issue, entirely the financing of Bruce Stadium. And Michael Moore, as we noted, went on to serve as health minister in Carnell's government, suggesting that confidential briefing didn't harm their working relationship, perhaps even help forge it.
And the biggest legacy, the impact on Australian law and legal practice. How fundamental was the change?
It was genuinely fundamental. Mann v. Carnell, along with the SO case decided around the same time, really nailed down the common law test for waiver of legal professional privilege in Australia.
The inconsistency test.
That's the one. The High Court made it absolutely clear. At common law, which applies to discovery, waiver happens if, and only if, the client's actions are inconsistent with maintaining the confidentiality the privilege protects. Forget subjective intentions or broad fairness arguments as the primary test. It's about objective inconsistency of conduct. Did what you do show you no longer intended to keep it secret from the person trying to get it?
And that was seen as a major clarification.
Huge. The Australian Law Reform Commission called it an important change, cementing this objective inconsistency test and moving away from potentially fuzzier earlier approaches. It provided much-needed clarity for lawyers advising clients.
What about that executive-legislature relationship? Did the ruling clarify how they can share information?
It did, effectively. The majority decision gives the green light for confidential briefings by ministers to MLAs, even involving legal advice, without automatically losing privilege, as long as the confidentiality is maintained. While McHugh worried about separation of powers, the majority, and Justice Kirby particularly, emphasize the practical need for these channels for responsible government to work. It allows oversight without blowing privilege wide open every time.
And for someone thinking of using preliminary discovery against the government today?
Mann v. Carnell stands as a major precedent. It shows that legal professional privilege is a very strong shield against preliminary discovery. You can't just go fishing for government legal advice hoping it helps your case. You need to show clear evidence that the government's actions have been objectively inconsistent with maintaining confidentiality against you specifically. Simply sharing it confidentially with an MLA for government purposes won't cut it.
So it's fascinating. A case born from one person's intense frustration over a settlement, his quest for answers, his belief he might have been wronged.
Becomes the very case where the High Court draws a clear line in the sand on one of the most important legal principles underpinning government function and litigation: legal professional privilege waiver.
It really shows how individual disputes can shape the legal landscape for everyone. It established that crucial test. Is the client's conduct inconsistent with keeping the communication confidential? If not, privilege holds.
A clear rule, but one that emerged from a complex balancing act, balancing government transparency, the need for confidential advice, legislative oversight,
Yeah.
and an individual's pursuit of truth.
Which leaves us and you listening with that enduring question. How do we strike that right balance? How do we hold government accountable, ensure transparency, but still allow it to get the candid advice it needs to function effectively? Does that inconsistency test, forged in Mann v. Carnell, get that balance right for the public interest?
It's the central tension, isn't it? And understanding this deep dive into Mann v. Carnell gives you the tools, hopefully, to think critically about that fundamental question in our democracy. It's a case whose ripples are still felt today.